So anyway, I want to share with you the most amazing tool that I use in my practice, something that makes me a superhero to my clients. It's not some amazing client portal where clients can go and pull down their documents and check the calendar or have a virtual cup of coffee. Instead, it's really 6 little words. Your secrets are safe with me. Because when I explain to my clients the duty of confidentiality, whether they're sophisticated or people who have never been involved in the court system, they're just amazed. They say, wow, you mean I can tell you something you're not going to tell my employer? I can tell you about my business and I don't need a non-disclosure agreement? It's just something that just wows them. It's the attorney-client privilege, and it's the bedrock of the relationship between attorneys and clients. It's the foundation of trust. When clients know that their secrets are safe with us, they feel willing to unload their burden. But in the 21st century, there's another reason why attorney-client privilege is so important. That's because it's our purple cow. It's our unique selling proposition. We have clients who are going to LegalZoom, who are getting documents off the internet and filling them out. But you know what? Those documents don't protect their confidences the way that we do. And moreover, we can say that it's backed up by an ethics obligation rather than some contractual privacy rights which can be breached. Now, it's true that the attorney-client privilege has been eroded over the past 20 years. We know that if you're a criminal defense attorney, you talk to your clients in prison, those communications aren't going to be privileged. If you're an employment attorney and you communicate by email with your clients in the workplace, that stuff is discoverable too. But what's more of a threat to attorney-client privilege in the 21st century than judicial fiat is technology. Technology is the kryptonite of confidentiality, because when we put everything out there, when nothing is private, when we live life in the open, there's no expectation of privacy anymore. And when there's no expectation of privacy, it's really difficult to have attorney-client privilege. So what I'm going to talk about today is how lawyers can pay more attention to that and what we can do to preserve the attorney-client privilege at a time when we need it more than ever. I'm not going to talk about cloud issues. You're going to hear a lot about the parade of horribles here at the tech show, about all the horrible things that can go wrong. That, to me, is data security. What I'm going to talk about relates more to the communications, the either intentional or accidental ways that we disclose information about our clients, and even worse, the way that we incite and invite our clients to give up personal information about themselves. And so I'm going to start with a couple of examples. Of course, as you know what type of example would be here without Twitter? And I found this on Twitter when I went to do research. Somebody posted, my client lied and said it to the judge. Ethical considerations, I'm thinking, yeah, fella, you got an ethics consideration when you broadcast that to 10,000 people on Twitter, for God's sakes. The other example that we're going to get to is this site called Blippy. This is like social marketing or something, where people have their credit card information posted. If they hire an attorney, that's something that's disclosed. Here you can see that people who have used LegalZoom, that information is put up there. It's another way of giving away that you've consulted with an attorney. Another example is the site Law Pivot. This is a site that was set up so that small entrepreneurs could get access to free legal advice. It's called crowdsourcing your confidential information. Is that not an oxymoron? Crowdsource and confidentiality? For God's sakes, this is lawyers who are encouraging this kind of thing. The other site that's kind of related to this is called Spunkle. This is that attorney auction site where clients go and post about their problem, and attorneys bid on it for the lowest rate. And it says something there like, look, your information is private. Only attorneys see it. Well, yeah, it's private from the internet, but if hundreds of attorneys are seeing it, where's the confidentiality there? The Foursquare, these types of locational things, lawyers have put up law firm presences on these sites. If your client comes and checks into the site, they're giving away the fact that they've retained you. It isn't entirely necessary for a lawyer to have a presence there unless they're interested in SEO. Now, the next one is the one I think is most dastardly. This is a firm that set up a support group for this drug called Yaz. And it's even hard to find out that it's sponsored by an attorney. You have to dig around. But basically, they get these women to come to the site and talk about these terrible things that happen to them on this drug. Oh, I'm bloated. It made me gain weight. Now I'm depressed. What am I going to do? They're encouraging this information just so they can get a case. This is a site that is in the medical profession. Essentially, what it does is it gets people to give up their HIPAA-protected healthcare information in exchange for a supportive community where you exchange information. But at what cost? Look at the data that's shared and sold. This is information arbitrage. They're selling biographical information, age, location. This is something that can come to the legal profession. Over in the UK, where they have the Legal Services Act, this is an article from The Guardian. This is somebody who was talking about how banks may eventually have lawyers do wills for free, not as a loss leader, which is a traditional business model, but to get information, to mine data about things about your mortgage. So what are we to do? Well, first of all, my response is we can't regulate. Let's not tell lawyers to stay off the site. That's just pathetic. We're not babies. I mean, we should expect more of people in the profession. The first thing that lawyers have to do is exercise some self-restraint. Maybe think a little bit about some of the stuff that they're doing online. Try to restrain your ego. Is it really necessary for you to post on Twitter, oh, I got a meeting with Martha Stewart, and we're going to talk about the SEC call that she just got? You don't have to put it out there. For God's sakes, use a little sense. We saw that with Quinn Emanuel, went and boasted about the settlement agreement on Twitter and breached a confidentiality agreement. The second thing is use the kid test. Would you want your son or your daughter going on Facebook and posting, oh, I've got this venereal disease, or I took this drug and it's making me, hallucinate? If you wouldn't want it for your kids, you shouldn't be wanting it for your clients. And finally, the last thing is take the confidentiality seriously. This is a time where clients are putting all kinds of information out there. They don't know what they're doing and they need guidance. They need a place to come. They need a place where they can be sure that their confidences can be kept a secret. If we focus on confidentiality and try to reinforce it, we can continue to be lawyers and superheroes for our clients. Thank you.